Now back to the show. This is The Law Show on CL 650.
Big crash. Well, I wish she'd listen to me.
Is that song called Big Crash? Okay. I don't know how Dwayne finds these gems, but that's kind of fitting for our guests here today. We have Kevin Hyde here from McQuarrie, LLP, along with Nate Hartney, both in the personal injury division there. And so we talked a little bit about, having an accident and liability has been assessed, I guess, by the adjuster. But that's not carved in stone. A lot of people would maybe find that surprising when the ICBC comes and says, well, you're 30% at fault or 60% at fault. You kind of feel like that, well, that's been decided already. But that's not entirely true, is it? And that's why you should have a lawyer look at your case.
Yeah, absolutely. So the typical scenario that we're all familiar with is you get an accident and ICBC will come back and say, you're 100% at fault or 50% at fault or whatever. If you're injured in that accident and they tell you you're 100% at fault, that doesn't mean you don't have a claim, because the adjuster's assessment and ICBC's assessment can be overruled by a judge. Mm-hmm. So if you're injured, you can go see a lawyer, and the lawyer will look at it and say, well, you know what, you're not 100% at fault. I think you're 50% at fault. So I'll take your case and we'll file an action and ultimately settle it with ICBC on the basis that you each party was 50% at fault. So you never just have to accept what they tell you in terms of their liability assessment.
I had a case actually where I was representing a client in a first motor vehicle accident where she wasn't at fault at all. And then there was an intervening accident I think it was about a year later. And she just told me she was at fault for the accident. And I kind of left it at that. But then I decided to follow up with her with another phone call and said, well, maybe explain to me in more details exactly what happened here. And what had happened is she was on a street, a side street, turning into her physiotherapist because she was getting treatment for the first accident. She slowed down and she passed the where she was turning into just by a little bit, slowed down and stopped. And a car tried to pass her into oncoming traffic that was coming from behind her. And then she signaled and made her turn, but didn't see the car behind her. And it hit her on the driver's side. It was quite a significant accident. And the ICBC adjuster, in those circumstances, deemed her 100% at fault. And she just took the ICBC adjuster's word that she was at fault, and there was nothing she could do about it. Clearly, in this case, as the vehicle that was on the proper side of the road stopped, signaled, and was making the turn, that vehicle should never have tried to pass her in that situation. Is likely 100% at fault. Or the best case scenario, this is some kind of liability split here. So her claim is still open on in the circumstances, and thank goodness I investigated a little more, and it just shows how people just take the adjuster's word for things, and that's not who makes these decisions on liability. These adjusters aren't lawyers. These adjusters aren't judges. They're just often making the decision that's perhaps in their best interest because it cuts off her claim and damages their first motor vehicle accident claim. Likely the other driver behind started a claim as well, and he was held 100% at fault. So it seems like an internal conflict within. They can deem both drivers 100% at fault in different claims. So
when you want to adjust this split liability, it has to go to court.
No, that's not true at all.
No?
No, not at all. So you come to see the lawyer, and the lawyer will do some investigation, maybe talk to some witnesses, and there will be settlement negotiations. And even in cases where liability is in dispute are more likely to go to trial, but than cases where it's not. But the overwhelming majority of those cases still don't.
Often there's very little investigation done at the beginning when ICBC makes their decision. And when they look more into it, such as the example I gave, we were negotiating essentially by the end to compromise that the other driver was 75% at fault, my client 25% at fault, and was not at fault at all for the first accident. So when we came to a settlement, it reflected that. We kind of went from that starting point. So you're still able to settle claims even if there's a liability in dispute.
So back to your point before the break, Nate, is if we'll pick a number of $100 and you're 75%, the other person's 75% at fault, whatever the settlement is, you get that percentage, right?
Yes, yeah. And even if you're,
And so what the reason I pick a round number is let's multiply that. Instead of $100, maybe it's $100,000 or $1 million.
Absolutely.
Now that 5 or 10% is a much bigger number.
For sure. I mean, if you have catastrophic injuries and you were 75% at fault, that's still a significant settlement, for your future care for the rest of your life. So it still is worth, consulting a lawyer, even if you think that you were the majority at fault, I guess.
Now, is there ever a situation where you rear end somebody that you can get out of you being 100% at fault? Because I've been on the highway and somebody's trying to make an exit quickly and they slide right in front of you, and then everybody puts their brakes on. You got nowhere to go. So if you hit that person, could you have that liability split?
Yes, for sure. There was actually a recent case called Varga and Candela from just a few months ago where this one went to trial, so it's a published decision. And the facts in that case were that driver 1 made a sudden lane change right in front of driver 2 and stopped, and driver 2 had no time to avoid rear-ending her. And most likely ICBC looked at that and they go, oh, rear end, he's 100% at fault because it's a summary process, right?
Driver 2.
It went to court, and the judge found that the rear end driver was actually only 25% at fault, and the driver that cut in front of him was 75% at fault. So the moral of this story is that even if you rear end someone, you're not always 100% at fault. You might be 0% at fault, or you might be 25% at fault. It all depends on the facts of the case.
Go see a lawyer.
Yeah.
One I've always heard talked about in accidents is if you rear end somebody, you're at fault. So if you have a daisy chain effect where a big truck hits a pickup truck, hits a mini, and then the mini hits the motorbike, then is it, how far back does that go, right? Like I'm just sitting in traffic waiting for the light to change. Then all of a sudden I'm hit from behind. I hit somebody in front of me. Am I 100% at fault, even though I hit somebody?
The reality is that, no, you're not. That's the answer to that. And what you do is when you see a lawyer to start your claim, you'd likely add all the vehicles involved, and then ICBC would contact the lawyer and say they'll admit liability on behalf of one of those defendants that they've deemed to be at fault in exchange for you releasing the other defendants that you've added to the claims, the other insured that they represent. So
after the winter we had here in Vancouver, one for the record books, I think. Has it been busier because of all of the snow?
Yes. Of course it has.
And is it just, does the snow complicate things for you trying to prove something because it was slippery, I couldn't stop because of the conditions, the roads weren't plowed, all those sorts of, can you say, well, I tried to stop, but the city hadn't cleared the streets in 3 weeks? So there is claims due to the weather and some people alleging the failure of the cities and municipalities to properly salt the streets, keep the conditions as safe as they should be, falling below what the standard of what was reasonable under the policies that were in place or should have been in place, where the actual city is getting added as a defendant in these claims, or third-partied in perhaps. That's interesting. All right.
Defendant.
When we come back, we're going to talk a little bit about how long of a period you have to make a claim or go to trial, hit and runs, and also we'll kind of wrap up our final thoughts here. And when we come back, we have in studio today Kevin Hyde and Nate Hartney, both lawyers at McQuarrie LLP on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.